We're going to dive straight into a 600-year-old legal mystery today. It's a case that, honestly, on the surface, looks like just a petty neighborhood dispute, but it actually forms the absolute foundation of modern business competition and tort law. We're talking about the famous Gloucester Grammar School case, decided way back in the year 1410.
Now, to really get why this matters, I want you to picture something. Let's bring this into the modern day for a second. Imagine you run this highly successful coaching institute in your city. You've built the whole thing from the ground up, you've got a steady stream of students paying tuition, everything's great. Then, out of nowhere, another teacher comes along and opens up a brand new coaching center literally right down the street. And to make matters worse, they charge way lower fees than you do. So naturally, your students jump ship. They leave your institute, join the new one, and boom, you're facing a massive financial loss. It feels incredibly unfair, right? I mean, your livelihood has just been wrecked. So the core question we're looking at in this explainer is, can you actually sue your competitor simply because you lost money? What does the law say about that?
Okay, let's dive into this. We're going to cover the rivalry itself, frame the exact legal issues, and look at the arguments from both sides. Then we'll break down the court's final ruling, unpack this concept called damage without legal injury, and finally wrap up with why this entire case still matters so much today.
Part 1. The rivalry. All right, let's transport ourselves back to England in the early 15th century and meet the master of the Gloucester Grammar School. Here's how this whole thing played out. Step 1. Our plaintiff is the master of a really well-established grammar school. Students are paying their tuition, things are going smoothly. Then comes Step 2. The defendant, who, by the way, is another fully qualified schoolmaster, decides to set up shop right nearby. But he doesn't just open a school. Step 3, he completely undercuts the competition by charging significantly lower tuition fees. And, well, Step 4 is pretty inevitable. Students flock to the much cheaper option, completely abandoning the plaintiff's school. So in Step 5, the plaintiff, who is now dealing with this massive drop in income, decides he's been wronged. He drags the new schoolmaster to the Court of Common Pleas, demanding compensation for basically ruining his business.
Part 2. Framing the legal issues.
So now that we have the backstory, let's step inside that 1410 courtroom and look at the actual puzzle the judges had to solve. They were looking at a really profound dilemma, boiling down to 3 main questions. Number 1, can a person recover damages merely because they suffered a financial loss? Number 2, does lawful competition actually amount to a legal wrong? And 3, is every economic injury actionable in law? Now, obviously, it's super easy to feel bad for that first schoolmaster. His business was decimated, but the court had to strip all the emotion away and ask a really tough question. Does the law exist to guarantee your business profits, or does it exist to protect something else entirely?
Part 3. Arguments of both parties.
Now, what's really interesting about this slide is seeing this direct courtroom clash between two rival educators. You can really see the tension here between moral fairness and strict legality. On the left side, the plaintiff's argument is basically just cause and effect. He's saying, look, you opened a school, you lured my students away with cheap fees, I lost my income, therefore, you owe me money. It's an argument totally rooted in his financial devastation. But take a look at the right side. The defendant's argument is honestly a masterclass in legal logic. He basically says, opening a school is a perfectly lawful activity. I didn't trespass on your property, I didn't physically harm you, I didn't break any contracts, therefore, absolutely no legal right was violated. He's arguing that healthy competition, even if it totally bankrupts a rival, just cannot create legal liability.
Part 4. The court's final ruling.
So the judges listened to all of this. They're weighing the obvious financial ruin of the plaintiff against the completely lawful conduct of the defendant. And here's the step-by-step logic they used to reach their historic decision. Step 1. The judges agreed that the defendant's conduct was, in fact, entirely lawful. Offering an education at a lower price, not a crime. Step 2. They determined that the plaintiff's financial loss, while obviously very real and super unfortunate, just wasn't enough on its own to create a cause of action. And finally, Step 3. Because no actual legal right of the plaintiff had been broken, I mean, nobody had a monopoly right to teach in Gloucester, the court concluded that no compensation could be awarded. They threw out the plaintiff's claim completely and ruled in favor of the defendant.
Part 5. Damage without legal injury. Now, this ruling didn't just settle a local spat between two schoolmasters. It birthed a foundational legal doctrine that is still used all over the world today. So the crucial point is this Latin phrase, Damnum Sine Injuria, literally, damage without legal injury. Let's break that down because it's super important. Damnum means damage, like actual financial loss, economic ruin, or even physical inconvenience. Injuria means a legal injury, meaning the violation of a legally recognized right.
So what the court essentially established here is that you can have massive damnum, you can lose literally all of your money, but if there is no injuria, meaning no violation of your actual legal rights, the law isn't going to step in and save you. Courts are there to protect rights, not to guarantee that your business survives fair competition.
To really wrap our heads around this, it helps to look at its exact opposite. On the left, we've got our Gloucester rule, Damnum Sine Injuria. You have damage, but no violated right, which means no legal remedy. But look at the right side, Injuria sin damno. This is the violation of a legal right without any actual damage. This concept was locked in later in the famous 1703 case of Ashby v. White, where a guy was wrongfully prevented from voting. Now, he didn't lose any money. He suffered zero financial damage, but his legal right to vote was violated, and the courts ruled that this is absolutely actionable. You can sue for that. This contrast perfectly highlights how tort law actually works. The law cares deeply if your legal rights are broken, but it honestly doesn't care if you just happen to lose a competitive business battle.
Part 6. Why this case matters.
So, it's been over 600 years. Why on earth are law students globally still studying a fight over a grammar school from 1410? Well, this brilliantly illustrates the long-lasting power of common law. The Gloucester Grammar School case established that doctrine of Damnum Sine Injuria, which created this vital shield for free markets. It formally recognized that lawful competition is not actionable. Think about it. Imagine if it were. Every single time a new restaurant opened and took some customers away from an older one, boom, there'd be a lawsuit. The entire economy would literally grind to a halt. This case drew a super clear, absolutely necessary line between actual damage and legal injury. It's still cited today in modern cases dealing with civil liability, economic loss, and corporate competition. It is for sure the foundational concept that lets capitalism actually function without being constantly paralyzed by litigation.
As we wrap up this explainer, I really want to leave you with this final thought. How do we perfectly balance protecting businesses with encouraging the fair competition that society actually needs? The Gloucester Grammar School case laid down a pretty harsh but totally necessary rule 600 years ago that just losing money doesn't entitle you to a legal rescue. But, as businesses evolve, as tech monopolies get bigger, and as competition gets way more complex, this ancient balance is constantly being tested. So think about that the next time you see two rival companies fighting it out for customers. The foundational rules of their game, they were written by two schoolmasters back in 1410. Thanks for joining me for this explainer, and definitely keep questioning the structures that shape our world.